I was born in the South, in Southside Virginia, when Plessy versus Ferguson was the law of the land that controlled every aspect of life in the African American world, from birth until death. My paternal grandmother, who somehow, having been born in 1840, became a midwife, and she delivered me in a farmhouse somewhat similar to that in which President Abraham Lincoln was born. All of the schools that I attended were segregated. Indeed, the first school I attended did not even have proper flooring. It wasn't until I was in law school that I had my first white teacher. But on the road to the law school, I had to first finish high school and college. And there was no high school for African Americans in the county in which I grew up. The high school opportunity was provided through a church-related black college in the community, for which the county paid some stipend to the teachers. Although the system was pretty devastating by design, we who did succeed were forced to develop a way of life by developing certain principles that were able to guide us. For example, going to church every Sunday was very important. And although some may have been reading the Bible purely for the biblical context, I was reading it even then to see how it could help shape a motto for life, and it did.
I was Attorney General when Governor Whitman decided to nominate Justice Coleman for the Supreme Court vacancy that had occurred when Justice Clifford retired. I remember thinking, what an extraordinary appointment. It's really, I think, valuable for a court to have people who come from different backgrounds. There are so many talented people. That other attribute, that diversity, is special in infusing an understanding in the court of what the facts really mean, how the law is applied, and we really, I think, cannot calculate that value. And I remember attending Justice Coleman's swearing in and thinking, what a very special person he is.
There were several cases in which I authored the opinion, both in the trial court, in the appellate division, and in the Supreme Court, that helped to break down some of the barriers of segregation. One case in the appellate division is pretty famous, called State versus Gilmore, in which historically prosecutors and defense lawyers, for that matter, all over the state of New Jersey would indiscriminately excuse persons of racial and ethnic minorities from serving on juries. And so when one of the lawyers at the courthouse in another case came down and told me what was going on in another courtroom, his question to me was, do I know of any case that he could give to the other lawyers to help them put an end to that? My response was, I do not know of one, but I promise you that if and when the opportunity comes, I would like to write an opinion, and that opportunity came early on after my appointment to the appellate division. And in that case, we decided that the prosecutors could not summarily discharge jurors who have been chosen through a pretty well-rounded process to come to the courthouse to serve as potential jurors, and then to turn around and allow the prosecutor and defense lawyers to excuse them pretty summarily. should not be allowed under our state constitution.
Judges, and Justice Coleman would probably be the first to tell you this, decide cases on the law and precedent and the facts in the case, the facts that are before the court. But from his background, he understood what it meant to be denied jury duty. And I say denied because it is a privilege for many people to serve, just simply because he was Black.
On the issue of cross-racial identification, I had another opportunity to write an opinion when I was in the Supreme Court that addressed that issue too. After doing extensive research using the social science studies, I concluded in the opinion that a special jury charge was required in order to alert the jury as to the unreliability potentiality in cross-racial identification. And since then, the New Jersey Supreme Court has extended that principle to deal with eyewitness identification that does not involve cross-racial identification. And in that same context, there was another case that legal service was involved in, and the issue there was whether or not someone who would satisfy the federal guideline of living below the poverty line had not paid her rent. And the landlord would add late charges to the unpaid rent and seek a judgment based on the total amount.
I remember in that case, a woman who was being evicted in a situation where she really did not understand, despite some real attempts on the part of the court and the system to educate her about what was happening. She didn't understand what her rights were. She did not understand some of the legal documents she was being asked to sign and to agree to. And there was, in the end, even though she made substantial efforts and ultimately was able to cobble together the money necessary for her rent, she did not understand that she was going to be evicted anyway in the circumstances that then existed. It was so evident that we need to help people who cannot get the representation they need, do not understand what the system is about. Additional information, ways of helping them to preserve their rights. It was a meaningful moment in the court's history and in the history of legal services of New Jersey.
During my years as a lawyer and as a jurist, I tried to create more civil and racial justice by ensuring that courthouse doors are just as open for the poor as for the rich. That was important to me because a judiciary that does not support that mission has forgotten its own mission.
He maintained throughout his life an optimism about what we can do as a society, about social justice. That is, whatever he had suffered, that didn't turn him into someone cynical or pessimistic. He came prepared to do battle, but prepared to do it in a reasoned way and to make his mark to change the world, and he did. He did that.